Chapter 4: Law on Partnership and Corporation. Learning objectives: to differentiate the various kinds of partnerships and corporations and the responsibilities of partner and incorporators. To identify the requirements in the formation and dissolution of partnerships and corporation. The topic outline: the law, discussion of the law, partnerships, advantages and classification. For any partnerships to work, the element of trust is essential and is more important than the resources of skills that the partners actually bring into the business. For the corporations, good governance and transparency is essential because of public trust. By Professor Frank Cavico, Nova Southeastern University. Law on Partnership. The law. Article 1767. By the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Discussion of the law. A partnership is an association of two or more persons to carry on as co-owners of a business for profit. The definition of a partnership does not include religious associations, conjugal partnerships, and other of a similar nature because a partnership, as defined by law, refers only to association the purpose of which is to obtain profit to be distributed among the partners. A partnership's contract is based on a trust and confidence. Hence, the fiduciary relation in a partnership stems from the principle of delectus personae, wherein no one can become a partner in a partnership without the consent of all the partners. The essential requisites of a partnership are: number 1, an agreement to contribute money, property, industry to a common fund. This is complied with if A. Each one of the partners bring or is obliged to bring something to the partnerships, and B. That which is brought becomes commonly property. Number 2. Intend to divide the profits among themselves. This is complied with if a partner is established to obtain profits. Profit must be common to all the parties, and profit or loss must be divided among the partners. The advantages of forming a partnership. Number 1, it is easy to form. Number 2, improved growth possibilities. Number 3, freedom from bureaucracy. Disadvantages of forming a partnership. Number 1 is the instability, difficulty in obtaining large sums of capital. Number 3 is firm is tied to the acts that judgment of one partner as agent. And number 4 is difficulty in severing partnership ties. The classification of partnerships. Number 1, according to the subject matter. A universal partnership, a partnership where all of the partners contribute all of their properties to the common fund and speak of no particular purpose or subject matter, as long as the purpose in forming a partnership is to obtain profits and is not contrary to law, moral, public order, and public policy. Nowadays, seldom if none do you experience business establishment forming a universal partnership. A particular partnership has for its object determinate things, their use or fruits, or a specific undertaking, or the exercise of a profession or vocation. Number 2, according to liability. General partnership, composed of general partners where liabilities extend to their personal properties. B is limited partnership, usually attached to the word LTD or limited at the end of the company name. One formed by two or more persons having as member one or more general partners and one or more limited partners, where the liability of the latter to third person is limited to their capital contribution. Number 3, according to duration. A partnership for a fixed term is one in which the term of its existence has been agreed upon expressly as when there is a definite period, or impliedly as when a particular enterprise or transaction is undertaken. The expiration of the term thus fixed or the accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. And the forms of partnership. A partnership can be in any form, even if not recorded at the Office of the Securities and Exchange Commission, except number 1, when it is stipulated; number 2, when its immovable property or real rights are contributed, in which case there must be a public instrument to which is attached an inventory of the immovable properties and signed by the parties. Otherwise, the partnership is void. Number 3. In case of limited partnership, the parties must a. Sign a swear to a certificate which shall state among others the name of the partnership, adding the word limited and the character of the business. B is filed for record the certificate in the Office of the Securities and Exchange Commission. Failure to comply with the foregoing formal requirements will only make the partnership a general partnership. The succeeding pages shows a sample each of the article of partnership for both a general partnership and a limited partnership. Obligation of the partners. Number 1. When contribution is money or property, if a partner promises to contribute money during the celebration of the contract and he fails to do so, he shall pay the interest and damages from the time he should have complied with without need of any demand. Number 2. Where contribution is industry, an industrial partner, a partner who merely contributed industry or services to the common fund, cannot engage in business for himself unless the partnership expressly permits him to do so, and if he should fail to do so, the capitalist partner may either exclude him from the firm or avail themselves of the benefits which he has obtained in violation of this provision, with a right to damages in either case. Number 3. Obligation of the capitalist partner. A capitalist partner, a partner who contributed money and property to the common fund, is prohibited from engaging in a business in competition with the partnership unless there is stipulation to the contrary. Otherwise, all profits of such partner belong to the partnership and all losses shall be for his account. Number 4. Responsibility between partnership and the partner. The partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership. It should also answering to each partner for the obligation he may have contribute in good faith in the interest of the partnership business and for risk in consequence of its management. Number 5. Sharing of profit and loss among partners. The distribution of profits and losses shall be in conformity with the agreement. If only the share in the profits is agreed upon, the share in the losses shall be in the same proportion. Number 6. Property rights of a partner. A partner cannot assign his right with respect to the specific partnership property for the partner's individual debts or for legal support. Number 8. Liability of individual partners to the third person. All partners, including the industrial partner, are liable pro rata with all their properties for contracts with third person provided they were entered into the name and for the account of the partnership, or B, under its signature, or C, B, person authorized to the act of partnership, and D, the partnership assets are already exhausted. Number 8. Liability of the limited partner. A limited partner is liable as a general. A. When he follows his surname to appear in the partnership name, and B. When he takes part of the control of the business. In this case, he shall have all the rights and power and be subject to all the restriction of a general partner, except that as to the other partners, he shall be preferred as to the return in his contribution and the share of the profit. Discussion of the law. Civil interdiction is defined as an accessory penalty for the commission of an offense, which deprives the offender during the time of his sentence of the rights of parental authority or guardianship, either as to the person or property of any ward, of marital authority, of the right to manage his property, and of the right to dispose of such property by any act or any conveyance inter vivos. Insolvency is defined as the financial condition in which one is unable to meet his obligation as dematured in the ordinary course of business, in which one liabilities exceed his asset at any given time. Order of liquidation for a general partnership. The law. Article 1839. In settling accounts between the partners after dissolution, the following rules shall be observed, subject to any agreement to the contrary. Number 2. Liabilities of the partnership shall rank in order of payment as follows. A. Those owing the creditors other than the partners. B. Those owing to partners other than for the capital and profit. C. Those owing to partners in respect of capital, and D. Those owing to partners in respect of profits. Order of liquidation for a limited partnership. The law. Article 1863. In settling accounts after dissolution, the liabilities of the partnership shall be entitled to the payment in the following order. Number 1. Those to creditors in the order of priority as provided by law, except those to the limited partners on account of their contribution, and to general partners. Number 2. Those to limited partners in respect to their share of the profits and other compensation by way of income on their contributions. Number 3. Those to limited partners in respect to the capital of their contribution, and 4. Those to general partners other than the for capital contribution, and 5. Those to general partners in respect to profits, and 6 is those to general partner in respect to capital. The law on corporation. The law. Section 2. Corporation defined. A corporation is an artificial being created by operation of law, having the right of succession and the power, attributes and properties expressly authorized by the law or incident to its existence. And the kinds of corporation. A stock corporation, one which has a capital stock divided into the shares and is authorized to distribute to the holders of such share or dividends or allotments of the surplus profits. Example is retained earnings. On the basis of the share held, a stock corporation is organized for profit. The governing body of a stock corporation is usually the board of directors. B. Non-stock corporation. One where no part of its income is distributable as dividends to its member, trustees, or officers, subject to the provision of the Code of Dissolution. A non-stock corporation is one not organized for profit. The governing body is usually the Board of Trustees. C. Corporation de jure. A corporation organized in accordance with the requirements of law. D. De facto corporation. A corporation where there exists a flaw in its incorporation. E. Public corporation. One formed or organized for the government or a portion of the state. It is created by its own charter for the exercise of a public function. Examples are barangay, cities, and municipalities. F. Private corporation. One form for some private purposes, aim, or end. It is created by incorporation under the General Corporation Law. This includes a government-owned and controlled corporation with an original charter and quasi-public corporation, a public corporation performing public functions. G. Corporation sole. One organized for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect of church. In this corporation, there is only one incorporator. H. Eleemosynary corporation. One organized for a charitable purpose. I. Domestic corporation. A corporation formed, organized, and existing under the laws of the Philippines. J. Foreign corporation. A corporation formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in their own country or states. Advantages of a corporate organization. Number 1, strong separate juridical personality. Number 2, limited liability to investors. 3, free transferability of units of ownership. 4, centralized management through the board of directors. 5 is professionalism. And 6 is easier to sell small amounts of stock to raise capital. And here are also the advantages of a corporate organization. Disadvantages of a corporate organization. Number 1 is extensive government regulation. Number 2 is double taxation. Number 3 is activities are limited by charter and various laws. And steps in the creation and organization of a corporation. Number 1 is promotion. Number 2 is incorporation. And number 3 is formal organization and commencement of the business operation. And that's all for the chapter 4. Thank you for listening.